Let's tidy up a few things that have been hanging out there over the weekend and today. First, we have some friends over at National Review. One in particular is trashing the hell out of Pam Bondi in the Department of Justice. Trashing the hell out of them for politicizing prosecutions. Politicizing investigations, for which they will one day be sorry. Now, I spent a lot of time at Maine Justice. When you read the case against Mayor Adams, it is a very, truly pathetic case, and the timing is outrageous. We have protections in place, or I thought we did, where before a U.S. attorney pulls the trigger like that in a highly political case with an election, a primary on the horizon, there needs to be consultations with the Attorney General of the United States. And perhaps there were. So why are there consultations with the Attorney General of the United States? Because he or she has the final say. That's why. We even have the Office of the U.S. Attorneys at Maine Justice, the purpose of which is to help coordinate with all 93 U.S. attorneys and the Assistant Attorney General for the Criminal Division, the Deputy Attorney General of the United States, under whom the criminal activities are overseen, and then ultimately the Attorney General of the United States. And so to make the allegation, because, 9 prosecutors, both in the Southern District of New York and Maine Justice, have resigned. There are literally 90,000 employees over the Department of Justice, thousands of prosecutors and investigators. Some of these resignations, no doubt, are ethical in nature, but others are intended to draw as much attention to the arguments and the claims of the person resigning as anything else. I've seen this myself. When Attorney General Meese was the Attorney General, there was a coordinated effort by the Associate Attorney General, the head of the Criminal Division, William Weld at the time, as well as their deputies, to resign over an independent counsel matter where they felt the Attorney General himself should resign. So I've seen these sorts of things before, and I don't get sucked into them, and neither should you. A lot of this is drama. And the headlines that the Department of Justice is out of control, the Department of Justice has this, the Department of Justice has that. 99.9% of the people at the Department of Justice aren't even paying attention to what the hell is going on in the Southern District of New York. The Southern District of New York holds itself out as the premier U.S. Attorney's Office. A lot of lawyers try to get jobs there as assistant attorneys general or special assistant attorneys general or what have you. Looks good on the resume. There's a level of arrogance in the Southern District of New York that really isn't in any other district, as a matter of fact, including the Eastern District of New York. Just because they bring a case doesn't make it right, doesn't make it just. And it doesn't mean the Attorney General of the United States, who ultimately has supervision over all 93 U.S. attorneys and their offices, should ignore them. And if she believes, or if her deputy believes, and in consultation with one another, that the case brought against Mayor Adams, and they do have access to virtually all the information, then they should do something about it. And it is courageous to do something about it because, as you can see, you get these individuals who write pieces or say things who are not encumbered with all the facts. There's no way they are. Unless, of course, the U.S. Attorney's Office is leaking to them. One would hope they're not. And so it's a very fair call, if that's the conclusion that's reached by the hierarchy at the Department of Justice. There's many lawyers who think it's a fair call, including the lawyers who represented Governor Bob McDonnell, who looked at it. including many other lawyers, including me. I'm no special pleader for Mayor Adams. I think he's a failure, to be perfectly honest with you. Maybe he's gotten better over time because he has seen the disaster of his more left-of-center policies. I don't much care. But I call him as I see him. It's that simple. And to jump in and make the assertion with little more than looking at public events, the way it's being made, and not once, not twice, but repeatedly, as if it's a fact because you happen to declare it, is really pretty damn outrageous. That's number one. Number two, the Department of Justice is supposed to do justice. When the prior regime at the Department of Justice was conducting itself in a way in which it was bringing these outrageous cases against the former president and then the candidate for the presidency, absolutely, unbelievably unprecedented, things we've never seen before. When the Attorney General makes an unconstitutional appointment, which two prior Attorneys General, including my former Attorney General, Ed Meese, says it's black and white that he absolutely violated the Appointments Clause, that raises serious questions, does it not? When a special counsel is appointed to investigate a political opponent, that's not the purpose of a special counsel. The purpose of a special counsel is to investigate within the family, within the House, the theory being that a U.S. Attorney's Office appointed by that administration cannot do an equal and just job of conducting an investigation. Whether you believe that or not is not the point. You don't then use that process at the Department of Justice, turn it on its head, and go after, say, Donald Trump, do you? The leaks that came out of this Department of Justice and the special counsel, the abuse of various evidence rules in the courtroom, the abuse of the grand jury process, and the changing of the grand juries in midstream. I could go on and on and on. You had at least one of their prosecutors accused of threatening one of the defense lawyers with losing his potential judgeship, for which he was said to be under consideration. And some of these lawyers who left eventually Donald Trump have spoken to me on and off the record. And they said the conduct of this Department of Justice was absolutely outrageous. And these aren't all individuals who march behind the Republican Party and Donald Trump. These are people who've been practicing for 30, 35 years, one of them 40 years. So what do? Do we ignore it? Do we ignore the fact that the prior regime in the Department of Justice rejected the 2000 memo? The 2000 memo. That is, the memo that the Department of Justice embraced, saying you don't indict public officials not just 60 days before an election, but the things you do and the things you say that might influence an election that are problematic. Or that you have this prosecutor who pushed the Supreme Court to the edge of the envelope on his immunity arguments. Just absolutely outrageous. And we could go on, but there's no point in going on. Is it legitimate, therefore, that Pam Bondi and the new people at the Department of Justice say, we want to look at this, we want to hold people accountable if they violated any rules or the law for sure, and we want to make sure this never happens again? Isn't that their job? To ensure that internally the Department of Justice isn't politically corrupt or motivated? Because I remember times when it was politically corrupt and motivated. I remember times when the Department of Justice went after Martin Luther King. I remember times when the Department of Justice authorized illegal wiretaps, including into Barry Goldwater's campaign. I remember the time when the Department of Justice authorized the White House to go into the Internal Revenue records of businessmen like Andrew Mellon and others who it didn't care for and didn't like. I remember the time not that long ago when Senator Ted Stevens of Alaska God rest his soul, he died in an airplane crash in Alaska, where he's brought to trial in Washington, D.C. on corruption charges. And it was later found out that the Department of Justice, the prosecutors, withheld evidence that would have helped the defense, that would have undermined the Department of Justice's case. How about the case of Bob McDonnell, where the same Jack Smith brought a case and basically reread the bribery statute, rewrote it so broadly that a unanimous Supreme Court, 8-0, overturned it. Even though the district judge didn't, even though the appellate panel didn't, the Supreme Court said, no, that's not right. I remember a time when the former administrator of NASA, Jim Beggs, he was an executive vice president, I think, at General Dynamics. The criminal division led the charge, the public integrity section. They brought in corruption charges against him in the course of the Reagan administration. I was chief of staff. Attorney General Meese was never comfortable with this. Not because it was Beggs or the administrator of the NASA, but because he looked at the charges. He spoke to the head of the criminal division, Bill Weld, who would later go on to be governor of Massachusetts, who would later resign, stabbing Meese in the back to try and force Meese out. Weld said, no, it's a slam dunk case. The problem is 17 months later, they dropped it because they didn't have what they needed to support the charges they had brought. The Attorney General of the United States, Ed Meese, directed the head of the criminal division, William Weld, to send a letter of apology to Mr. Beggs. William Weld refused in the final days of the Meese attorney generalship. He said, look, it was brought in good faith. We made mistakes. There's nothing to apologize for. Of course, they destroyed the man's life. They broke him financially. He had to resign as the administrator of NASA, but no big deal. So one of his final acts, Ed Meese called me into his office before he left. And he had me write, as he dictated, a personal letter of apology to Mr. Beggs. And then he had me release it to the media so they understood that what was done to him was outrageous. I read to you a few weeks ago what Robert Jackson, former Attorney General, former Associate Justice of the Supreme Court, took time off from his responsibilities as a justice to be the chief prosecutor for the United States at the Nuremberg trials. But I reminded you in 1940 what he said to a room full of federal prosecutors. He warned them, you're the most powerful people in peacetime America, bar none. You have the power from soup to nuts to control the criminal, legal fate of a citizen. The way in which you conduct yourself, the way in which you write your briefs and the charges, the way in which you release press releases and speak to the media, the way in which you threaten individuals and talk to their friends and family to get the information out, and all through the process, helping to pick the jury, if convicted, having enormous input in the sentencing and so forth and so on. There's nobody more powerful, he said, than a federal prosecutor. So when we have lapdogs who should know better, especially after the experiences of the last several years, who just bark out the usual pablum about how this is being politicized by dropping the case against Adams. They have it backwards, inside out, upside down. They are being politicized through their grotesque self-righteousness. And their Helen Keller tactics, refusing to look into this, are appalling.